ahead, Winnie.
We are live.
The Honorable Justices of the Supreme Court, hear ye, hear ye, hear ye. All persons having business before this court are admonished to draw nigh and give their attention to the court.
Good morning and welcome to the Kansas Supreme Court. I'd like to welcome both the counsel who are arguing this morning, as well as those who are on our Supreme Court Live channel. I would also like to welcome Judge Lori Walton Fleming, who is sitting with the court this morning, as well as one case this afternoon. She is sitting for us due to the recent retirement of Justice Carol Beyer. Judge Fleming has served as a district court judge in the 11th Judicial District since May of 2012. The 11th Judicial District is a 3-county district in the far southwest corner of the state, Crawford, Cherokee, and Labette County. On our first case this morning, we had a judge from the far northwest corner of our state. So we're hitting opposite ends of the state this morning with our visiting judges. Judge Fleming has taken time from her busy docket to help us out. We are very honored to have her with us today, Judge Fleming.
Thank you, Chief.
With that, I would now ask Mr. Doug Shima, the clerk of the appellate court, to call this morning's 11 a.m. docket. Mr. Shima.
Thank you, Your Honor. May it please the court. The 11 a.m. docket for Wednesday, October 28, 2020 consists of one case. Appeal number 121181, State of Kansas versus Mark Holley III, Sedgwick County, briefs both sides. The appellant has reserved 3 minutes rebuttal time. Your Honor, we are ready to proceed.
Okay. Counsel, would you please state your appearances?
May it please the court, Michelle Davis on behalf of Mark Holley. For argument.
Good morning, Your Honors. May it please the court, Assistant District Attorney Lance Gillette on behalf of the state of Kansas, present and ready for argument.
Thank you, counsel. Ms. Davis, you may proceed with your argument.
Thank you, Chief Justice. The convictions in this case arose from a series of events from March and April of 2017 involving individuals who didn't know each other, who arranged transactions through Facebook Messenger and other internet in order to, the state alleges that Mr. Holley was either the buyer or the seller of certain items. And the issues that I raised in the brief primarily focused on 2 of those events. And so I'll focus on the facts for those. The first issue is that Mr. Holley requested a self-defense instruction. And this was a situation where he had 2 individuals, a woman and a man, had driven to the house or driven to a location to sell Mr. Holley marijuana, is what was supposed to be happening. And Mr. Holley got into the back seat and the seller was in the front seat. There was one eyewitness to the event, which would have been the woman who was the driver. Ultimately, the man in the front seat ended up shot and he died as a result. The state charged Mr. Holley with attempted robbery and then a felony murder, which is a killing in the commission of the attempted robbery. Mr. Holley's defense at trial is that it was the man selling the marijuana who actually had tried to rob him and that he had fired the shot in self-defense and then fled the scene. There was one shot that the individual through the top shoulder area. He was struck in the right top chest shoulder area. And so it was interesting because Mr. Holley was sitting in the back seat and the state's evidence was that he got out of the car at some point during the robbery. The district court denied the requested instruction. The prosecutor argued that it wasn't legally appropriate, The district court agreed that it was factually appropriate based on the evidence that the man in the front seat, that he had a gun was found, and that he had apparently attempted to fire the gun because there was a round jammed in the chamber of the gun. So based on the evidence, the district court agreed it was factually appropriate. The district court applied an outdated standard that basically said once the state charges a forcible felony like attempted robbery, then you don't give the self-defense instruction. The newer standard is that you go ahead and you instruct the jury on the law and you allow the jury to decide. So basically, once the defense puts on sufficient evidence of circumstances that would justify the use of deadly force in defense of yourself, it's up to the jury to then decide. And I think that the state, my reading of the state's brief is that the state agrees the instruction was legally and factually appropriate. So I think all we're talking about at this point is whether the error was harmless or not.
Counsel, I have perhaps a esoteric question. I think what you call the outdated standard was the rule announced in our cases like Bell and Kilpatrick. Is that right?
That predated Bartlett. That would
Right.
Yes.
So my question is, if the instruction was not legally appropriate at the time it was requested, do we then ever apply a change in the law retroactively to say that it would have been legally appropriate under a new standard?
My understanding is we don't have that situation in this case. My understanding is that the Bartlett case had come out several months before the trial in this case. And
Okay, so my understanding of the timeline is not correct then, because Bartlett was available to the parties and the district court at the time the decision was made.
That's correct. And just unfortunately,
Thank
everybody
you.
was going on their understanding of the law instead of checking and making sure that it's a standard that had been around for a long time. So hopefully I'm correct on that time frame. And so this is just more a situation of error. And at this point, what the remedy is. And it's our argument that this court should apply the constitutional harmless error standard based on the cases that I cite in my brief, and that based on the constitutional standard.
Matter which standard we apply? In other words, can you prevail even if we apply the statutory harmlessness standard?
Well, yeah, I think the case law is pretty clear here that the constitutional standard applies. The state contests that. But if you look at Andrew, that's a case that came out, requested defense of, it was a defense of the dwelling. And this court applied the constitutional standard. So, and it's basically, I just hate to concede the point, it's the fundamental right to present a defense under the federal constitution, and also the state, there's argument for the Kansas Constitution also. So the state, it's our contention, the state has to prove beyond a reasonable doubt that it didn't affect the outcome. And what the state's trying to say is that they find Mr. Holley's version of events to be incredible. But a lot of what Mr. Holley was trying to say at trial was I wasn't even involved in marijuana. That I had changed my mind and I wasn't even trying to buy the marijuana. If you get rid of some of those facts and you get down to just the part about the use of force, which was that the driver of the car, she was on her phone and not really paying attention. And her testimony is also inconsistent because according to her, Mr. Holley handed the marijuana back before the shooting took place. And that doesn't really make any sense. And then they never found the marijuana in the car. And then you've got the round in the chamber. And it's not really for this court to judge witness credibility. This is an issue for the jury to decide. If there's facts to support the defense, this is a jury question. This court has the opportunity to view the witnesses and decide. I'm sorry, Your Honor.
No, that's okay. The format makes this difficult. I think I was asking something a lot more simple, which is my understanding is, or at least I presume, you're not pinning all of your hopes for a reversal on us adopting the constitutional harmlessness standard. You would still argue that we should reverse even under the lower harmlessness standard.
I can agree with that, just based on the fact that this comes down to credibility and how a jury would have viewed Mr. Holley, and this court can't determine that based on the record. And then if there's no other questions, I'll go ahead and move on to the other issues on the brief.
Well, I just have a question, and maybe you're going to move on to the other issue having to deal with restitution. But if we agree with you on your first issue, was all the restitution ordered in this case based upon the death of Mr. Smith and the expenses related to his circumstance, as opposed to the other victims on the other charges?
You know, to tell you the truth, Justice Rosen, I'm not 100% on that.
Okay, well, my question is if that is the case, do we reach the question on restitution if it goes back for another trial?
I would say no.
Okay.
The second issue is, you know, you brought up the restitution, so I'll go ahead and jump to that. Basically, the issue is that the jury should be deciding restitution. I raised this issue. I mean, obviously, our concern here is the conviction. I raised this simply to preserve Mr. Holley's claim. There are a tsunami of cases coming this court's way on this issue. I would simply point this court, there's an excellent resource. The Court of Appeals recently in Robeson, that's at 120903. A few months ago issued an opinion with both sides of it, very well fleshed out, because Judge Lieben did a dissent. They reached the issue. Judge Bruns wrote a majority opinion, great resource, extensive analysis of the case law in state and federal jurisdictions on this, as well as the history in Kansas. And then Judge Lieben wrote the opposing point of view. That's just an excellent resource that really fleshes this issue out better than I can do in this argument. So with that note, and I would just point the court to that case because I'm just the first wave on this. I'd like to deal with the second issue also in the time that I have left, which was the incident where Mr. Holley got into the car and there was a man in the front seat supposedly Mr. Holley was selling a phone to him. He said Mr. Holley pulled out a gun and took his wallet. There were two small children in the back seat, a 1- and a 2-year-old. And our second issue is that the child endangerment, the evidence does not support the child endangerment convictions, simply just because the state was required to prove that he knowingly placed a child in a situation where health may be endangered and that's a reasonable probability. I mean, the statute was not designed, this court said in Cummings, the statute was not designed to criminalize all potential risk to children. It has to be a reasonable probability of likelihood of harm. The state's evidence here just didn't do it because the only evidence the state had is the driver's speculation that when Mr. Holley got out of the car, the gun may have been waved at the children. There was no evidence here to support the standard. And in addition, the court erred by giving, well, not erred, but the court gave a shotgun instruction. So the jury could have convicted Mr. Holley based on, not that he knew that the result was reasonably certain to happen, but based on some other mental state. And that was an awareness of the nature of his conduct or awareness of the circumstances. The state didn't even put on any evidence that everything happened in the front seat. There was no evidence.
Counsel, you don't think that it's just sort of a common sense, reasonable inference a jury could draw that a weapon being brandished in a closed automobile endangers the occupants of the vehicle?
Well, that's the question, is how you define the endangered. And this court has said they have to show reasonable probability of likelihood of harm. You can't speculate. It can't be the injury could happen. This is Kansas. Guns are around children. The standard can't be because a gun was around a child. And I understand that this was in the criminal context, but simply just because a gun was around a child can't be enough to meet that standard. And that's what this court's decision in Cummings was all about. There's got to be something more than just potential for harm. That really concludes my prepared comments.
If we agree with your claims with respect to the murder conviction, but disagree with you on the child endangerment conviction, what is your requested remedy?
You know, normally this court will remand for a complete trial on all the charges, but I do understand that these were separate incidents. I don't know that I have a really good position. I would have to ask for remand on all counts, but I acknowledge the separate incidents in this case.
And just a factual question, am I correct that the car where the endangerment, for that count, the car we're talking about was a small compact car?
I can't disagree with that, Justice Luker. I'm not really sure.
Okay.
But again, I think that's still, the inference is still, I think the state needed a little bit more in this case.
And does the fact that he made a threat or allegedly made a threat, is that increases at least slightly the risk to the child, doesn't it?
Right, but again, I acknowledge that. Again, though, that probably scared the driver. But again, it has to be something more than, there has to be a likelihood of harm. And just a possibility is not enough.
Are there other questions? Okay, thank you, Ms. Davis.
Thank you.
Mr. Gillette?
Thank you, Chief Justice. May it please the court. I will respond to the two primary issues that have been argued here today and would accept any questions on the other issues. I want to start with the self-defense instruction claim. And I think that what we have here is an unfortunate circumstance where the state has conceded that the issue is preserved. We've conceded that technically under Bartlett, that instruction is appropriate. And I would concur with my friend on the other side that Bartlett was decided shortly before this trial. I think this is just a circumstance where the long-standing, well-settled rules changing that close to a trial date was simply overlooked by the parties. I think then we have to look at whether or not it's factually appropriate. And I can tell the court that the state structured its brief in this case for a specific reason. What we have encountered in the light of Bartlett and the subsequent cases that have come from there is that, as distasteful as it is, when we're encountered with a situation where, such as this case, where a defendant takes the stand and provides a version of events for which there is absolutely no support other than his own mind, we are stuck in a position where whether or not it's factually appropriate, technically, but that is only because the defendant testified to a series of events that make no sense and are flatly contradicted by every other witness and every bit of physical evidence in this case.
I appreciate that concern, but isn't there some other evidence that supports the self-defense, like the jammed gun?
Respectfully, Your Honor, no. There's the only evidence of the, other than the defendant's testimony that the victim had a gun, was that came from the eyewitness, his girlfriend, Miss Reed, who was the driver, and she did not see him, the victim, reach for a gun until after he had been shot. And defendant's claim that he was shot at, there's, I suppose, an arguable support there, because Amari thought that the victim, Deshawn, had fired the gun. But again, her thought is not in and of itself sufficient. So no, respectfully.
Well, just I understand your editorializing on the state of the case law, that you disagree with it, but it sounded like you conceded that it's factually appropriate here.
My editorialization was not necessarily to be overly critical of the case law. It's just the position we find ourselves in. And I think that I want to be clear that if I conceded too much in this brief, basically is my point. Whether the level of factual appropriateness, if I've conceded too much, then please, by all means, tell the state and clarify in this opinion what would be considered factually appropriate. But as for the purposes of the argument today, I would concede in my brief that my analysis shifts on to harmlessness, because technically, because if we only engage in the myopic review of the defendant's testimony, technically it's factually appropriate to have given this instruction. That moves us to the harmlessness inquiry. And on this point, the state has 2 points that I want to make. First of all, the state does believe that the statutory harmless error test applies here. And that is because while a defendant is entitled to a defense, he has a constitutional right to assert a defense. What defense and how that defense may be asserted are matters of statutory law. Specifically in this case, obviously.
Would it be constitutional for the legislature to repeal the self-defense statutes?
Well, first I would say I don't know that that question is before this court today, but I would say that before the current self-defense statutes came into place, we didn't have this claim or this defense necessarily available. I think that's probably why we're having some of the argument that we are today about the ability to assert the right to self-defense. So I think that, many defenses are restricted by statutes. We've seen not only self-defense, but alibi, mental disease or defect. These things are restricted by statute, and the statutory harmless error test should apply here. The second point that I want to make is that the state is in no way shying away from the constitutional harmless error standard in this case, should the court elect to apply that standard. With all due respect, there is absolutely no way to view this evidence and find the defendant credible. It is just an absolute impossibility based on the record in this case. I would point out that in the defendant's own testimony, a couple of things. He lied to the detectives and admitted that he had lied to the detectives. It is reasonable for a jury to conclude that if a defendant would lie to the detectives, he may lie to them, the ones that are tasked with potentially holding him responsible for his actions. The detectives also gave the defendant a clear opportunity during their interview with him to assert self-defense. He did not. A jury would absolutely have considered that. Then when you look at just what his claims were, he accuses the Brookses, who he stole their gun and eventually used it to commit the murder. He accuses them of lying. He accuses Mr. Albin, the first victim, when he endangered the children. He accuses him of not being accurate and of being a racist. He accuses his third victim, Mr. Chang, of not being accurate. He provided contradictory evidence to Haley Williams, Amari Reed, his own sister. He contradicted his own sister. Essentially, the defendant's testimony was that everyone else is lying. He is the fount of truth and the only one to be believed. And it is from that position that the defense makes their argument here today. And the state's point is that that is absolutely not credible. The physical evidence also did not match with the defendant's story. Deshaun never fired his weapon. There was a misfire. It did not go off. Defendant claimed that Deshaun reached out through the window to point the gun at him. Deshaun's window is closed. That was shown by physical evidence, including an Axon video by an officer who was on scene within 1 minute and 30 seconds. This isn't a situation where Amari had an opportunity to conceal any evidence. The evidence also showed that Deshaun was shot while inside the door, likely with his door closed. And that came from Amari's testimony. And it also came from the physical evidence that showed blood spatter inside the door on some paperwork, and then also blood drops. And the testimony was that those are distinct, different events that would have caused those things to happen. I would also note the defendant's own testimony was not consistent regarding his need for the use of deadly force. At one point, he claimed that he was trying to intentionally shoot Deshaun in the shoulder, quote, just to slow him down so I can have a chance to get away, run away. That was at record volume 15, page 107. Shortly thereafter, Defendant responded to a leading question about whether he was in fear that Deshaun was going to hurt or murder him. He responds simply, quote, "That is correct." At yet another time, defendant seemed to suggest that the fatal shot, that what made it fatal, was Deshaun's moving in response to him pointing a gun at Deshaun. So we have inconsistent states of mind coming from defendant's own mouth. His additional story about his brother serendipitously delivering marijuana to him free of charge beforehand, meriting him, which would have caused him to cancel the planned transaction with Amari and Deshaun, is not credible, frankly, nor is a story that he would be willing to pay these drug dealers for a car ride across town. Certainly anyone would understand that they're not going to be thrilled if they call off a drug deal. I would also note that the defendant's only arguments on this point were to point at Amari Reed and the marijuana. While Amari Reed did not see the defendant take the marijuana, that is absolutely not evidence that the defendant did not, in fact, take the marijuana. The marijuana was gone. The defendant was later found with a substantial amount of marijuana after he'd been in a house all day with people coming and going. And he was also found with an amount of packaging that would have been equated with a large amount of marijuana. Let's see. Again, the only other point that the defense argued was that the victim, Deshaun, tried to fire his gun. Again, that happened after he was shot. And everything else, even in the defendant's own brief, points exclusively to defendant's testimony. That is not merit reversal in this case. The evidence was overwhelming. No reasonable juror would have believed defendant's testimony and given him a pass for his behavior in this case. This was not a defense. Self-defense did not merit a defense in this case. If there are no other questions on that, I'll touch on the knowing argument regarding the charges with the two children. The state initially presses a preservation and briefing problem with this. The state does not understand how a defendant can challenge sufficiency of the evidence, but then omit from the record evidence directly contrary to their position, or at least evidence even that directly bears on their claim. To that end, the state did add the photographs of the victim's car, Mr. Albin, where the two children were located. I believe it's Exhibit 12D. The court can look at it. It was a very small, compact car. It had been recently cleaned. It was spotless. The windows were not tinted. You could see the child seats in the back seat from the passenger side where defendant entered the car. There is no further evidence necessary to show that defendant knowingly endangered these children when he pulled the gun. I think that Justice Lukert, I think your point was well taken. We also have a threat in this case, indicating the defendant's is very willing to have a gun. We have increased tension when the victim, Mr. Albin, tried to keep his driver's license. The defendant, while pointing the gun at him, tells him, no, 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 you're not doing that, and refused to let him keep the driver's license. So again, I don't.
Can you address defense counsel's argument that the statute under which he was convicted requires more than the potential for harm?
Yes, I would cite to the Cummings case as well. And while no 609 letter was filed in this case, Patillo is another recent case that draws the distinction. What we're talking about here is not an actual harm, but that the child's life, body, or health may be endangered. We are talking about a potentiality, creating a circumstance.
Right. So that's the statute you're quoting. The statute uses the word or the phrase may be endangered.
Yes.
And I guess I'm asking you to respond directly to the claim that merely showing the potential of danger is not sufficient under the statute. That does seem to contradict the statutory language. Is that argument just incorrect as a matter of law?
I don't know that I would go as far as saying it's incorrect as a matter of law, but what I would go as far as saying is that a potentiality and maybe are so close that when the state's evidence, that it's probably, I think Your Honor is probably, that would probably be a misstatement of law. I think that maybe does talk about a potential. I think that the further pick instructions, including those given in this case, that talk about a reasonable probability, again, probability, we're talking about likelihood. Likelihood means more than a faint possibility. It is a possibility plus, this with the slightest plus. I think that the circumstances here overwhelmingly supported defendant's knowing endangerment of Mr. Albin's children, with him pulling the gun in the car, waving the gun in the car, waving it as he got out of the car. Keep in mind, time and motion are absolutely relevant factors that the jury would have considered here. This happened in a short period of time. The defendant was moving while trying to commit a robbery and succeeding in committing a robbery and making a threat. If there are no other questions.
Just to wrap up, you're not disputing the rule that this court has enunciated that this is a reasonable probability standard?
Correct, I'm not.
Okay. For a bit, it sounded like you were arguing that it's lower than reasonable probability because the statutory language just says may be endangered.
And that's why I wanted to go ahead and mention the other additional pick instructions, including those that were given here. We are talking about a reasonable probability, a likelihood, more than a faint or remote possibility. This isn't just a sheer possibility. It's possibility plus a little bit more, maybe, is what the statutory language says. And again, I think that the evidence in this case overwhelmingly satisfied that burden. Chief Justice Lukert, I see I'm out of time. If there are any other questions, Justice Rosen, I know you mentioned the restitution issue earlier. I would welcome any questions. But
my question is the restitution order related solely to the decedent and his circumstance?
Thank you, Your Honor. And respectfully, and I have to concur with my friend on the other side. I don't recall specifically which charges it was attributed to, but what I can tell, Your Honor, is that the only amount of restitution ordered in the instant case was agreed to by the defendant. The singular portion of restitution that he disputed was not ordered. Seeing no further questions, the state would respectfully request that this court uphold the defendant's convictions and sentence. Thank you all very much for your time this morning.
Are there any other questions? Thank you, Mr. Gillette.
I have a question.
Justice Wilson has one.
Sure.
Mr. Gillette, when the defendant got out of the car, was there any verbal threat in addition to the allegation that he was waving the gun?
In Mr. Albin's car?
Yes.
I would have to get pretty granular there. I know that the threat, I think that he does make this statement, "I'm going to gas you," is made at that same time. And or I'm going to gas your shit, actually, pardon the language, but I believe it was the quote. Obviously, that's not necessarily directed strictly at Mr. Albin. It could be his car, or it could be his kids in the back seat.
Are there any other questions? Thank you, Mr. Gillette.
Thank you. Your
Ms. Davis, you reserve 3 minutes.
I'm a little confused. The statute does say may be endangered. That's awfully vague. And this court has upheld the constitutionality of that statute on the basis that the state has to prove probability. Not possibility, probability. So in order for the statute to be constitutional, this court has imposed a standard upon it. So the state can't really have it both ways. This court was clear in the Cummings case and other cases about that. The problem here is that the driver said when Mr. Holley got out of the car, there was an opportunity for the gun to be waved. He never said the gun was actually waved. He said, "I wasn't paying attention. There was an opportunity." And when Mr. Holley got out of the car, the threat was towards the driver to get out of here. You need to get out of here. There was no threat directed towards the children. There was no testimony of him even looking at the children. So I think in order to meet the standard, the state would have to do that. Some sort of threat directed towards the children, some kind of action by Mr. Holley directed towards the children, or incorporating the children. And there was none of that. Everything was directed towards the driver.
Doesn't reasonable probability mean something more than a faint or remote possibility?
The likelihood of harm, not speculation. That harm could happen, not surmise.
And then we review the evidentiary record in the light most favorable to the state on that issue.
On a sufficiency claim.
Yep.
On a sufficiency claim. But again, I think it's our argument that even under that standard, there just wasn't the evidence here. There wasn't enough evidence here, even under that standard. And I don't think the evidence is contested. It's the light most favorable is. There just wasn't. The state says I don't put any evidence in my brief to support the state's point of view, which I disagree with, but there just wasn't the evidence here. That's kind of my point. And then on the harmlessness, on the self-defense, that's the whole point of the trial. The whole point of the trial was to have the jury decide, did Mr. Holley act in self-defense or not? That was his defense. That was the whole point of the jury trial. So if you take that away, if he can't instruct the jury on it and his lawyer can't argue it in closing argument, then and then to affirm that on appeal, when you've just taken away his right to a fair trial and a jury decision on this issue. On that basis, we would ask this court to reverse that conviction.
Real quickly, Ms. Davis, do you believe that it would be unconstitutional for the legislature to repeal the self-defense statutes?
Unconstitutional. You know, this goes to his right to present a defense. Given that the statutes are there, they could take the statutes away. That's something I'd have to look into. I couldn't just answer that off the top of my head. But given that the statutes are there, and then that goes, it's beyond a statutory right. It's a right to present his defense because the statutes are there. I'm not sure if that answers your question, but that's the best I can do right now.
Thank you.
Are there any other questions of counsel?
Sorry, here. Yeah, let me follow up on that last question, counsel, with you. If you didn't have the statute on self-defense, you still would have been able to argue the facts of self-defense in attacking each of the elements of murder, would you not?
You know, the judge directed counsel not to argue self-defense. So you could try and argue that he wasn't committing the attempted robbery, but that would be about it.
Yeah, I think it's probably a bad question on my part anyway, because I forgot this was felony murder. I keep confusing this one with a different case that had a second-degree murder count floating around in it. So we've got too many cases this week. But with felony murder, I think my question wouldn't be applicable. So sorry.
All right.
Any other questions? Thank you to both counsel for your arguments this morning. The court will take this matter under advisement. We are now in recess until 1:30 this afternoon.